I thought today during lunch we'd go back and watch. It'll be just under 40 minutes with some parts skipped of bond hearing, Young Thug's bond hearing. It's an old footage from 11 Alive. The exact date is July 21st, 2023. So the sound is worse than what we're used to today. But this is me rolling out the TV, the teacher during the break so the teacher can eat their lunch. We're rolling out the old TV that's strapped to the cart, and we'll get caught up here. First is going to be Brian Steele making arguments, and then we're going to see Love respond. So, oh yeah, okay, so while I do this, I'm going to go get the gift. Thank you for reminding me. I will go get that. I'm going to get my snack bar and the YouTube gift. So, I'll be back. Keep you guys entertained in the meantime. I think we've got captions turned on. And I'm telling you, I'm starting at half volume and then I'm going to increase it. So protect your eardrums if you have your volume turned up. Adjust accordingly before we get there.
Okay. Mr. Steele and Mr. Weinstein, I'm prepared at this point in time for you to go forward with your renewed motions for bond. So, Mr. Steele, do you want to go ahead and begin, sir? Yes. Since I know you need to be someplace else.
Of course.
Okay. All right, go right ahead then, sir.
Good morning, Your Honor, Madam Prosecutors, Mr. Prosecutor, all the lawyers here on behalf of the other people, on behalf of Mr. Jeffery Williams, Mr. Adams and I would like the court to reconsider its denial on 2 previous occasions of bail. We filed this motion on April 24th, 2023, and we alleged that Mr. Williams has been in custody since May 9, 2022. It's the date of his arrest. As the court previously heard, and if you need me to go over it, I will, but I'm assuming that this honorable court remembers the previous bond hearings and all the witnesses and exhibits that we placed before the court.
I do, sir.
I assumed you did. Mr. Williams, as you know and remember, did not flee when law enforcement officers came to his home on May 9th, 2022. He came out of his house. He called me, actually, and then came out of his house and was not in any way anything but compliant. It's now been more than 14 months so far. As the court may know and remember, the only potential nutritional foods consumed by Mr. Williams since May 9, 2022 include carrots, rice, lettuce, beans, and hot dogs. He mostly consumes products which have absolutely no nutritional benefits, which are M&Ms, chips, other processed or artificial bagged chemical substances. The lights, as the court may remember, in the small, isolated, solitary cell that Mr. Williams is housed in an off-site county. The lights are always on. They are brighter than the lights in this courtroom. So sleeping with bright lights in his face all the time, if he can get to sleep. And that is a form of torture which is not compatible with necessary restoration, sleep, restorative sleep required for Mr. Williams, who is a person on trial and needs to assist his counsel. Your Honor, this lifestyle for the past 14 plus months has caused physical harm to Mr. Williams. As the court recalls, he was taken to the hospital. If the court does not know, Mr. Williams gave me permission, it is for his kidneys. Mr. Williams was raised in total poverty. He is used to not seeking medical help because he could not afford saying when he was injured or hurt. But he comes in this courtroom every day, writhing from pain from his kidneys. The kidneys removes the waste and extra water from the blood, evacuates through the body the through urine to maintain balances of the body's substantive fluids, to keep proper balance and levels of potassium, calcium, and sodium. The diet consumed by Mr. Williams endangers his health. Pretrial incarceration, Your Honor, is not supposed to damage a person's mind, spirit, or body. It is not for punishment. And this physical incarceration for such a long period of time, and the trial is estimated to last 6 to 9 months, and that's a considerable amount of time. The court has always said, I will put you on trial right away. I'm very aware that I denied bond to your client, and we appreciate that. We filed demand for speedy trial statutorily and constitutionally. But it is still a long time. As the court may notice, takes note of Mr. Williams, he has gained tremendous weight. If he's weighed now compared to the time he weighed on May 9th, you will see how much weight he has gained. He does not fit into his clothing anymore. He has all new clothing, and this is a problem caused by the kidneys and the lack of nutrition and exercise. Your Honor, the support for the community is still here with Mr. Williams. It remains here, as I previously showed this honorable court, to a packed courtroom. There are people who have not wavered at all. His family is all from this area. They love him and devoted to him. I speak with them weekly, if not more. His friends have stayed with him. Co-workers of Mr. Williams in the music industry. One is a gentleman who is on your screen in courtroom 8H, as in happy. His name is Jeff, which is Geoff, Ogunlesi, Ogunlesi. He has flown across our country to be here today when he found out that this honorable court set the hearing on Tuesday. He is in, if you need him, he is in courtroom 8H, and he will speak to the court if needed. There are professionals of the highest, officers of publicly traded company, the record label, that are on your Zoom. Mr. Kevin Lyles, L-I-L-E-S, and he authorized me to tell you that he again embraced in total his previous sworn live testimony before this honorable court, and he stands by it with all of his power and might, and is willing to answer any of your questions that you would have of the prosecution for bond for Mr. Williams. Within this past month, Your Honor, Mr. Williams released a record. It was
Your Honor, I'm going to object to this proffer opening, or this portion of it, as irrelevant to a bond hearing.
I can answer that if I need to. It goes to his employment and his steadiness, employment in the industry, and in this trial at this time. He has still maintained total employment, and he's still active.
Okay, all right, I'll allow it.
He is the number, that record, Your Honor, became the #1 rap record in
Objection, Your Honor, if I may finish my objection. Objection to as to
What's the basis? Relevance? I'm going to overrule the objection.
Thank you.
This time. All right.
Is the #1 rap record.
Let's move on, Mr. Steele. I understand it. You've convinced me that he's employable. So.
Well, I think the court should know it's also #2 record in any field. And I think that that's important for the court to realize there's no risk of violating condition of bond. This gentleman is an accomplished superstar in music, and I think that should weigh heavily that he would not jeopardize that by violating any condition of bond. Your Honor, America's justice system is built on the presumption that bail should be granted if there are any conditions that can be factored to ensure that the community is safe, the person does not pose a danger to the community, witnesses will not be intimidated, there will be no obstruction of justice, the person will not, in this case Mr. Williams, will not commit a felony or any crime, it says felony, but any crime while out on bond, and that Mr. Williams will appear in court. Because if we do it the other way, and maintain people and house people and warehouse them as Mr. Williams has been, then the presumption of innocence, which is our entire standard in Georgia, is gone because he's being presumed to be guilty. Your Honor, Georgia, unlike some states, for purposes of pretrial bond, the presumption of innocence remains with Mr. Williams accused of any offense, even a capital offense, which Mr. Williams is not charged with a capital offense, from arrest and even during trial. That's Vanderford, V-A-N-D-E-R-F-O-R-D versus Brand, B-R-A-N-D. It's 126 Georgia, 67 and 70, 1906. That means, Your Honor, that prior to trial, this honorable court must view Mr. Williams to be innocent.
I do. We don't look. I understand that you're trying to meet your burden in the sense of for the 4 factors under Allah. So I'm going to assume that I take into account the prior testimony that you've given in this particular case. Is there anything that you want other than the updated issues as to his record release recently? And employability. Is there anything else you want to augment that with?
Yes.
And then I'll let the state respond and present anything they may have to the contrary.
Yes.
Okay.
I have seen and I've been here for every bond hearing except one, Mr. Miles Farley. I was not present for that. I've seen this honorable court deny every person's bond who's in this indictment. But then, 7 months later, approximately, I saw the state who called all these people that they are a danger to community. They cannot fashion this honorable court cannot fashion any conditions of bond that would permit bond to be granted. And then 7 months later, the prosecution for 8 co-indictees offered, and this court accepted, negotiated pleas of time served. I can't wrap that around my mind.
What does that have to do with your case and your bond? I mean, each individual defendant is on his or her, in this case, their own merit. So why does that have anything to do with you?
Because I don't believe that the
your client, I should say.
It's fine to say me, but I don't believe that the proffers you're getting from the state are accurate. They have been proven to be inaccurate. I heard Mr.
Unfortunately, that's the way the law goes at this point in time in our legislature.
This sounds like deja vu because this is a 2023 hearing and we just heard Bruce Harvey on Thursday last week make the same argument. Look at that. How things don't change.
Legislature hasn't addressed that. I mean, you've asked me to take a look at that. It's a different standard, pre-trial as opposed to when we're in trial. So, I mean, I understand that. I know you'll probably review that at some point in time, but at this point, I'm stuck with what I'm stuck with in terms of the legal posture of what the Constitution and the case law allows me to do.
There is no case that says that there's a difference between pre-trial and in-trial. That is not accurate.
In terms of the standard for motions and requirement for witnesses and live witnesses, should there be?
I misunderstood. I thought you were talking about bond law.
No.
Okay.
No, sir.
But you did grant bond. I was not present, but you did grant bond for Mr. Miles Farley. And there has to be a way that...
On the individual circumstances of Mr. Farley. Mr. Williams I have to judge it on his particular circumstances.
I'm judging on Mr. Williams. I think Mr. Williams is more than bond eligible. Your Honor, we still have the same officers willing to supervise and surround a home that will have no electronics and no visitors. There will be no computer, no cell phone, and law enforcement officers outside of the house. We will pay for transportation to and from the courthouse. Otherwise, with an ankle monitor on his person, he does not leave that home. Mr. Adams and I and our other co-workers would request to meet with Mr. Williams inside that home on weekends and at nights. But other than us, nobody comes in. We can leave our electronics outside and bring paper copies because that's what I do at the outside jail anyway with Mr. Williams. Now, sometimes they do let me come in with my iPad to share discovery with Mr. Williams. I have to ask special permission, and I can do that through the court. But, Your Honor, that is That is a factor that should be considered by this honorable court, that Mr. Williams can live at a location that can be vetted by this honorable court and law enforcement and the district attorney's office. I've gone further, not only with local police officers. If you don't like local police officers, I'm not saying anything wrong, but if for whatever reason that is not sufficient, there is a former Secret Service agent, there is a former U.S. Marshal that would take the responsibility of securing and transporting Mr. Williams in a home by himself and following every condition of bond, which we would ask for at this point, no visitors except legal, and not to leave the house except that he had to go to a hospital and on an ankle monitor. Your Honor, liberty is the norm in our community, and this custodial detention prior to trial, when there are conditions that can be fashioned, is against our law. I will answer any of your questions. Mr. Ogunlesi will answer your questions, but he is Mr. Williams' manager. He will answer any questions, but he is behind Mr. Williams 100%, and Mr. Kevin Lyles is with the record label, and he also is with Mr. Williams, and as I said, I incorporate his prior testimony. Your Honor, I want to answer any of your questions. I want to thank you always, but this is a big case with a lot of discovery. We got discovery yesterday evening. I go through with Mr. Williams. I'm with him every day. I'm in court with him. I'm on a Zoom call with him, privileged Zoom call at the jail, or I'm with him at the jail. It is a lot better for us if he can stay awake, if he can participate and assist, and there are conditions that we have, because he has the resources. That doesn't mean a resource to flee, like you heard he can rent a plane. He's not doing that. He has too much to lose, and he's too recognizable. Thank you, sir.
Okay. Thank you, Mr. Steele. All right. Ms. Love or Ms. Hilton, ladies.
Thank you, Your Honor. Your Honor, to begin with, I noticed that Mr. Steele referenced this status, the state that we're in, as pretrial. I noticed that and noted it because I wanted to make certain that the record is clear that we are currently in trial. We are not at a pretrial status or state. Mr. Steele referenced the fact that he has demanded a constitutional and a statutory speedy trial. And Mr. Steele also referenced the fact that the court promised or guaranteed that his client would receive one, and in fact, the court has upheld that promise, and we are in trial. The statutes in the case law that reference bail and bond also use pretrial release interchangeably with bail and bond. And so I just wanted to point out that we are currently in trial. Also, Your Honor, since the time that this court first found that the defendant poses a risk of committing additional felonies and poses a flight risk, there has been no change in circumstances beyond what Mr. Steele has described as the defendant's discomfort, his dissatisfaction with the food that he is given, his choice to only eat certain foods that are provided, and that's it. Using the rationale that Mr. Steele employs, it's tantamount to being unconstitutional to confine anyone, given the description that he has made of his client's circumstances and his assertion that every person should have the right to be free from those type of circumstances. I want the court to take note of the fact that the legislature, in enacting the statute for which Mr. Williams is charged, said that they wanted to make certain that the community is free of intimidation and threats caused by criminal street gangs, understanding that the state has the burden of proving all of the charges alleged in the indictment at trial. We are at a position, however, where we can point to circumstances that reflect that the defendant poses a significant risk of committing additional felonies. These acts that the defendant has committed go very far back. They include acts of intimidation during the time that his brother, Your Honor, I am proffering as an officer of the court.
Yeah, let her finish, please, Mr. Steele.
I apologize, I'm opposing objections.
What was the basis?
It goes against the law for presumption of innocence. This is the charges in the indictment which the court has to presume innocent. It's an improper argument.
I believe it's just her proffer. I understand the legal requirement, and your client is presumed innocent. But I think Ms. Love is proffering how Mr. Williams is or continues to be a danger to the community.
Thank you, Your Honor.
Using no irrelevant information, it's the indictment. That's what Ms. Love is referring to.
It is not.
I don't think she's referring to the indictment. I think she's referring to acts that she claims will support the issues of bond. Bond is different from...
But then what does she do when trial starts? She wants to consider any and all things as acts relating to like prior bad act evidence, like overt acts or intrinsic acts. But here, she pretends that's not the case.
Trial on the merits.
I understand that. I listened intently, and this is the indictment, and that's what Ms. Love just stated.
It's the charging document, but I understand, Mr. Steele, that it's different. The state has the burden. Bond is different than proof at trial. I understand that. Do you have any further objections, sir?
The 401 and 402 relevant.
All right, I'm going to overrule the objection. Go ahead, madam.
Thank you, Judge. The defendant, as far back as the time when his brother, Mr. Greer, who was before the court earlier this year, was initially set to be on trial, was one of the witnesses, and in fact, a person very close to the defendant, called the police and indicated that the defendant had messaged her, snitch hoes get murked, them and their kids.
Is this Mr. Williams you're referring to?
It is.
I did not get that.
Snitch hoes get what?
Murked, M-U-R-K-E-D.
Get murked and what else?
Murked, them and their kids.
Okay, I got it.
Your Honor, in 2015, Mr. Steele may present the objection that this is part of the indictment, but I can play the actual video where the defendant proclaims, so people lie to their mama, lie to their sister, lie to their children, and then want to get in court and tell the God's honest truth. You need to be killed, bro. That's from me and YSL. Those were his words. Judge, the intimidation factor and the risk of committing additional felonies that the defendant presents is not small. I know that you have heard proffers from prior prosecutors and you've heard evidence in previous bail hearings regarding witnesses' representations as it relates to this defendant. I can state, having experienced them myself, that the witnesses have expressed extreme reluctance. One said, with fear in his voice, he's different now. He's not the same. He moves like a man with millions of dollars behind his name. And in fact, the circumstances presented to you by Mr. Steele in both this hearing and in previous hearings reflect a similar sentiment. He moves like a man with $1 million behind his name. His hands won't get dirty, but people will enact his wishes. Since the time that we have been in this trial, we have seen it was captured on surveillance footage from inside this courtroom. One defendant who was on trial with this defendant bring to Mr. Williams Percocet in open court. Since the time that this trial has begun, we have had no less than 20 incidents, less than 20 incidents involving various crimes from drugs, shanks, and attacks being committed while the people who have been charged in this indictment are in fact confined. We have recordings of persons who are charged with Mr. Williams reaching out to other parties on the indictment, requesting permission from Mr. Williams to do harm to an opposition member who is in jail with the calling party. We have calls that are recorded of persons reaching out to Mr. Williams and conveying Mr. Williams' phone number and telling the called party, save this number under my name, just in case, the police get the phone. Everyone inside and who is associated with YSL knows who they need to keep the hands clean for, because Mr. Williams is the money that attracts the action and the willingness to act. When the shooting occurred that is referenced in the indictment of the bus for which Jimmy Winfrey was not convicted, it occurred at the same time that Mr. Williams was on stage in the other artist's hometown getting a not so receptive reaction from the audience. Your Honor, in 2015, of course, the court is aware that the state alleges that Mr. Donovan Thomas was killed as a result of conflict with opposition members, and that the vehicle, we do and can state that witnesses state that the vehicle that was used was one rented by Mr. Williams. We have proffers from persons who have pled, who have said that Mr. Williams then gave everyone money to get out of town that same night. In 2015, understanding that this particular evidence won't be used at trial, much like hearsay is inadmissible, but in 2015, Mr. Williams is found with guns and drugs inside his home, one of them purchased through a straw purchase. You would think, after being arrested for that in 2022, he wouldn't have a cache of drugs inside his kitchen, a whole drug store, in fact, inside his kitchen. But not only does he have that, he has guns that have been modified with switches to make them automatic and other firearms inside his home. The person who is listed on the indictment, Mr. Jamari Holmes, as a victim of murder and for which Rodelius Ryan and Ron Blaylock were convicted, those persons, after the killing, placed on social media something akin to slime over hose. In 2022, after two persons who are friends with this defendant are gunned down and killed, the same day or a day after, a picture is posted with Mr. Chamel drinks by Kelvin Watts. And the picture has a zipper face over it and two black shells underneath. A day or two later, Chamel drinks is gunned down. The defendant is charged with being a leader of YSL. The legislature made a point of carving out a separate and additional statute for one who is the leader. Because though the leader may be the one that associates want to keep the hands clean for, they are the ones with the most influence. Jurors have come in and expressed or have shown themselves to be unwilling to be truthful out of fear. Witnesses are afraid and intimidated.
I don't know about the jurors, but the witnesses are the only ones I can listen to in terms of proper what you're telling me at this point in time that you've actually interviewed. So
yes.
I'll make that clear.
Thank you.
All right.
Your Honor, even after, again, being arrested and having been found with drugs and guns in his home, the defendant in DeKalb County is stopped and found with drugs and guns. I believe that at a previous bond hearing, prior FTA was referenced by the prosecution. Mr. Steele's assertions regarding the nutritional content of the food that the defendant has chosen to consume while he has been confined does not rise to the level of warranting additional circumstances that merit the defendant's release during trial. We would ask that the court find that based on the actions of the defendant, he presents a risk of committing additional felonies, and that he poses a risk of intimidating or threatening witnesses. Your Honor, incidents prior to the ones charged in this indictment involve the defendant's presence at other violent felonies, his participation in them, and witnesses' statements that Thug made me do it, I knew I should have followed my mind and ran with him. Other people who are named in the indictment were charged and later convicted, but the defendant is the one who managed to avoid being accountable or held accountable for those actions.
Ms. Love, can I ask you a couple of clarifications? When did the
Snitch hoes get murked?
snitch hoes get murked, and then they and their kids get
That was in 2010 at the time of Quintavious Greer's trial.
okay?
And the incidents where calls were made,
Was that more recently?
yes, it
When was
is.
that?
Those were made in 2021.
Any calls or any other things after the commencement of this particular trial? Anything after December of 2022 or into 2023?
As we are still reviewing the calls that we have received, I've not come upon ones from 2023. I can only point with respect to things that have been observed by officers and members of the state's staff, the drug transactions that have occurred.
Do you have interviews with more recently? Some of the things you told me, are those based upon witness interviews that you have indicated that have been held sometime by your office, sometime during 2022?
Yes.
And 2023?
Yes.
Okay. All right. All right, madam, anything else?
Not at this time, Your Honor.
Okay.
Thank you.
All right.
Prosecution to hand to the court and to Mr. Williams' counsel, snitch hoes get murked, then their kids in 2010. That did not happen.
She's an officer of the court,
And so am I.
okay,
And you should.
I believe the law. Mr. Samuels attempted to, when he was involved in this case, to have me do that, and the law doesn't.
You guys notice how Steele will say the words, and the jury's not here, but you notice how he'll say the words when he's quoting Love?
To order the prosecution to.
God, don't buff. Ugh, I broke it.
Your Honor, I reject the proffer. I would ask you to order the prosecution to hand to the court and to Mr. Williams' counsel, snitch hoes get murked, then their kids in 2010. That did not happen.
She's an officer of the court,
And so am I.
okay,
And you should.
I believe the law. Mr. Samuels attempted to, when he was involved in this case, to have me do that, and the law doesn't require me to do that.
Your Honor, if you rely on that, you should know what you're relying on. It does not exist. Calls made in 2021, it's a wiretap that they may be referring to. Mr. Williams is not on a wiretap. I've listened to every call.
Okay, well, I'm going to give that less weight than I would the conversations that Ms. Love has had with recent witnesses in 22 and 23.
Let me give you something out of discovery. Mr. Eppinger's mother said that Jeffery Williams ruined her son's life, recruited him into this YSL criminal street gang, and led her son down the wrong path. Mr. Eppinger's mother is mentally ill. She's never met Jeffery Williams, and her son never said that. That is the type of information you are being given today to rely upon. Ask the state for the proof. There's no problem. You'd ask me for the proof, and I'd say, here it is. Your Honor, this conversation that Ms. Love wants to have about the legislature made it different for leaders, she does not cite any provision of law, because it doesn't exist. Bond.
It's not really relevant for my bond determination at this point in time in terms of, I mean, it's still, I have to look at the Iowa factors, and that's my principal guiding foundation.
But aren't you concerned at some point, Your Honor, that you're being told misrepresentations? At some point, do you just think...
If that's the case, then there are other remedies for this court to undertake and other bodies that this court can refer those matters to. I have to take your proffers that you tell me as counsel, when we all go through a very lengthy licensure to include a professional ethics MPRE examination given in tandem with our licensure as lawyers. So I think most people take that pretty seriously, because to lie to the tribunal is pretty serious. So if I find that out later on, I'll make the appropriate decision.
And Mr. Williams will still be potentially rotting in jail. The rubber has met the road, Your Honor. I'm telling the court, I'm imploring the court to, if you're relying on that proffer, please ask to see the evidence. Going back, every other term used here is in the indictment. Those are the allegations. The state wants to turn it upside down and say, well, just presume that this happened. Presume now a search that was illegal. Let's presume that as well. The failure to appear, what they didn't tell you was there was no notice given. It was a speeding ticket that got dismissed. That's the failure to appear. Your Honor, you are being given information that is not appropriate. I'm telling the court that Mr. Williams, I would not come before the court for a third time. Mr. Williams can have a bond with whatever conditions the court needs. It will just be the right thing to do under law, under Ayala, which is AYALA. I'll answer any of the other questions, but the tour bus, Mr. Williams was, Mr. Love rather put Mr. Williams in that. Mr. Williams was out of state. He was not charged in Cobb County, and there's a memo from the Cobb County District Attorney. He's now a Superior Court Judge, the Honorable then District Attorney Reynolds, saying there is not enough evidence to charge Mr. Williams in any crime involving the tour bus shooting that involved a gentleman who performs under the name Little Wayne. That's what you're being told, though, today, that somehow Mr. Williams was involved. And I'm telling you different.
All right, sir. Thank you.
I'm muted. I'm boomerang. So what do you guys think of about that? We obviously know that bond was not granted. It's a big ask, right? When, even though they're not saying Jeffery Williams is the one who pulled the trigger on something, he's still technically being charged in a way that makes him responsible for a murder one charge. So it's a big ask to ask for a bond for someone that's supposed to be a ringleader, that's calling all these shots for major crimes. But hearing the argument in retrospect, and really Love's strongest argument against it, in my opinion, was, well, Your Honor, Jeffery Williams is the one that asked for a speedy trial. So, you know, if he wants a speedy trial, then he can't also argue that he's going to be held in custody for too long. Like, that was kind of like the strongest thing I think she made. I do think the things that she argued would be appropriate things to argue at a bond hearing, but the problem is her representations of things. She'll take something, a witness saying, you know, he's got $1 million behind him that he needs to protect. He needs to protect his name. That sounds like someone with a brand that's signed to a record label that could cut him at any minute if he does something to damage the brand, or he doesn't want to damage his own brand. But Love took that statement from a witness and interpreted it herself to say it meant so he was going to pay people to do his dirty work so his hands would stay clean. That is not a quote from the witness. She added all of that in. And we just got to watch how Brian Steele has had to call this out time and time again since before the jury was even sat in this trial. Like, how much of what we just watched is different from today? Again, this is a rewatch of a bond hearing, second or third request for bond for Jeffery Williams on July 21st, 2023.